These are all going to be waivers.
That's correct, Judge.
Mr. Mills, it's correct that you're waiving your right to have a preliminary examination in these matters?
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed. You understand that?
Yes, sir.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution of these matters?
Yes, sir.
People also waive their rights.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on all the felony counts with the misdemeanors following. Counsel, you acknowledge receipt of the information.
I do acknowledge receipt of information, Your Honor.
You waive their reading.
And we do waive a formal reading, Your Honor, at this time.
And your client stands mute to this.
And it stands mute, Judge, yes.
All right. Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in these matters will be set.
June 2nd at 1:30 p.m. with Judge Hamud.
June 2nd, 2025, 1:30, Judge Hamud.
And Judge, I know we just did waive the exam, Judge, but may I briefly address bond, Judge?
You may.
So my client has been in custody since the arrest in this particular matter. I understand that these are serious charges, Judge, but I would also note that my client technically does not have a extensive or criminal history, Judge. His family is in court today. His bond right now is $500,000. Your Honor, I'm asking for a significant bond reduction. He's been unable to post bond. He was working prior to being incarcerated, Judge. His employment is definitely in jeopardy. Again, Judge, I know one of the charges is a capital offense. But, Your Honor, I'm asking the court to at least consider, if possible, Judge, a $100,000 bond in this particular case, Judge, as opposed to $500,000. I believe that that's still a significant bond to post if he's able to.
How much did you say?
I'm asking for at least $100,000 as opposed to $500,000.
All right. I'm sorry I interrupted.
Oh, and so Judge, I just think that that's still a significant bond to post if he's able to post it. But Judge, $500,000 is unattainable at this time, and I also believe that at this time it's excessive given the circumstances, John.
Yeah, the people respectfully request that the bond remains currently set. The most troubling is that there's an armed robbery, which is a capital offense that people were able to proceed today. We brought in the victim, the Marine Corps from North Carolina. He's president of Courtroom, so that is obviously a capital offense. It did involve in that instance the defendant in possession of a firearm. The oldest case involved a LawNet investigation. It subsequently conducted a search warrant. The defendant was ultimately found in possession of distribution quantities of amphetamine, firearms, as well as 3D printers, items used to make what are commonly called ghost guns, as well as clock switches to modify the guns. And then when the police went to arrest him on the older warrant, this was back about 6 weeks ago, the defendant attempted to flee, was in his vehicle, involved in a pursuit involving both the state police as well as Pittsfield Township Police Department, and was again found in possession of a Glock with an extended magazine and more controlled substances, and the search in that yielded other items associated with the modification of firearms and the ghost guns. All of that is both very troubling from a community safety standpoint, as well as the defendant's potential posing a flight risk. So I would ask that bond remains currently set.
Anything else?
Judge, even if the court would impose a tether, Your Honor, or house arrest, Judge, just the opportunity to at least post a bond in this case for $500,000, it's excessive. And again, Judge, I think even with everything the prosecutor just mentioned, I think $100,000 cash bond is still a significant bond to post, and gives him a huge financial stake in his bond that he wouldn't not comply or be a danger to the community or be a safety risk in any way, shape, or form, Judge.
Well, I would consider the defendant to be a safety risk given at least the allegations that are contained in the is represented by the people in this case. I think that given all of the circumstances, this bond is set appropriately. I will deny the request for a bond modification in this case. You can take it up before Judge Wood.
All right, thank you, Judge.
Thank you.
And Alex Warren Green on behalf of Mr. Jantz. Mr. Jantz, can you state your name for the court?
James Jantz.
All right. He's waiving his right.
It's Correct, Your Honor. He's executing the form right now. In exchange for his waiver, the people have agreed to reduce the OWI third to an OWI second in circuit court, and have extended a sentencing agreement to no prison.
That's correct.
Mr. Jans, you're waiving your right to a preliminary examination.
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1, 2, and 3 with 4 and 5 filed.
Your Honor, we acknowledge receipt of the information, waive its reading, and stand mute.
Defendant never waived formal reading, standing mute. Excuse me. Court will enter a not guilty plea as to all 5 counts. Pretrial in this matter will be set June 3rd, 2025, 1:30 before Judge Combs.
3 weeks, sir.
Bond will continue. Thank you. I don't know. I don't have a loose information for whatever reason.
I will have
There wasn't one in that one. I don't know what's happening because it's like the 5th file today where we didn't have them. All right,
Your Honor.
thank you.
that's fine.
Right, who's on the other side of the person? Childers?
Here.
Okay. Let's call the case of the people versus Chalice McClung.
Andrew Childers appearing on behalf of the people.
I'm the Long Brown deputy, public defender, being waiting on behalf of my client, Mr. Charles McClung.
All right. All right, thank you. All right, date and time set for examination. Ready to proceed, you may call your first witness.
I'll start with, we'll have Deputy Phillips testify first.
Please come forward and be sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth. State and spell your first and last name for the record.
Alex, A-L-E-S, P-H-I-L-L-I-P-S.
All right, main court.
Sir, how are you currently employed?
I am currently employed with the Washington County Sheriff's Office,
And how long have you worked there?
approximately 5 years.
Were you working in that capacity back on April the 15th of this year, 2025?
I was,
Were you alone or with a partner at the time?
I had a partner,
Who was that?
Deputy Bovee.
Directing your attention to, I believe it was kind of mid-morning on that date, April 15th. Were you dispatched in relation to a possible stolen vehicle?
I was,
Okay, tell me about that.
gave me a call for a reported unit at the hotel located at 1275 South Huron. Myself and my partner initially called and spoke to the complainant to a preliminary statement and then advised videos, cameras at the hotel.
Okay, and this, what kind of hotel is this on here?
It was in Marriott.
Okay. Did you and your partner physically respond to that location, or did you just communicate via phone?
We did respond out.
Okay. Did you or your partner make contact with the owner of that vehicle?
We did.
Okay. Tell me about that.
She advised that she left her car there.
Two things, Your Honor. One, I'm not offering this for the truth of the matter asserted, but only to explain, in part, to explain what the deputies did. But further, and I'll get to this, permission to use property hearsay is admissible under 1101B8 at preliminary examination, and I do intend to elicit that testimony.
All right, very good. Then I'll overrule the objection with the understanding that it's not offered for the truth of the matter, except to the extent it goes to the issue of permission.
Correct. Thank you. Go ahead, Deputy Phillips.
She advised that she left her car in the parking lot overnight, and when she returned home, the vehicle was not there.
Okay. Did she let you know if anyone had permission to take that vehicle at that time?
I'm not knowledge of the relevance of this. I don't. But it's my understanding we're not doing UDA, right? Just.
Oh, I didn't know that.
Oh. Okay.
What?
I was planning on making sure I can prove all my.
Oh, no. Oh, yeah, come on. I guess. Record should reflect we had a bench conference in this case, and while the testimony Deputy Phillips has started, my understanding is that there was additional evidence that came that is now there, that as a result of a search of a phone that is now in the possession or will be in the possession that need to be turned over to the defendants. That's correct, and I apologize. I am last minute covering this. The assigned APA became ill and had to excuse herself. And I trust Mr. Brown that he had this conversation with Ms. Douglas earlier in the morning. So I have no problem with that. And I think that based on that new discovery and the fact that we would ultimately likely have to just recall the same witnesses, that moving this whole exam to a new date to allow an opportunity to receive and review that discovery maybe makes the most sense. So what I will do is I'll move to my next available date, which is June 3rd, 2025, 9 a.m. That's before me. All right.
Thank you.
Yeah. All right. Thank you.